So what I was saying was the book I put out in 2010 derived from a project that I undertook when I was working in Geneva with a group called the International Council on Human Rights Policy in 2007 and 8. And what we did was an initial deep dive, if you like, into the questions concerning human rights and climate change, which resulted in this report that you can see here on the slide, with the equally inspired title "Climate Change and Human Rights: a Rough Guide." Now, the reason I go back to this is that was quite a long time ago. The report came out in 2008. What we did in Geneva in this think tank, which was not a part of the UN, but was established by a group of people who were involved in setting up the Office of the High Commissioner of Human Rights initially, and which had the job of forward thinking on human rights questions to inform UN and other international processes. We gathered together academics and practitioners and people who've been thinking about this from around the world to Geneva, and had a round table, and then produced a report on that basis. And what's fascinating to me now, and it was fascinating at the time, was this was 2007. I had personally been working on climate change since 1996. I'd been working on human rights since about 2000, and there was almost no work available at that time looking at both of these issues side by side, despite the fact that I think we all agree in the room the links between them are very obvious and clear. At the time, there was a case that had been brought to the Inter-American Court, the Inuit case, which the American court deemed inadmissible, but they had a hearing about it in any case. Very interesting case, which looked entirely at climate impacts in the Arctic regions. And there was a movement taking place in the Maldives. I see David is in the Maldives right now. The Maldives have long been one of the primary actors in forwarding this set of issues. Their then Prime Minister, President Mohammed Nasheed, organized a meeting there, which produced something called the Mali Declaration and gave us some of our initial language that you actually find in the Paris Agreement on the set of issues. So there wasn't much there, and what was there was relatively scant. So what we tried to do was to open the field up to a bit more academic and policy context. And the reason I'm going back to it now is partly because in lots of ways I'm not really working so much in this field anymore, but also because I think it's a good time to sort of take stock, global stock taking, a la Article 14 of Paris, to take stock and see where things have moved on in the last 15 odd years and how well we're doing. And of course, we heard a relatively upbeat assessment just now. I arrived slightly late, but that's how it sounded to me. I'm probably less upbeat myself, in part because, of course, in the last 15 years, we have failed entirely to bring down greenhouse gas emissions. And that's not just the last 15 years, that's the last 34 years since Rio in 1992. It's an extraordinary failure, absolutely extraordinary failure, which leaves us in a really quite serious situation when it comes to human rights. When we started looking at this, part of our thinking was, it was already 20 years after Rio, part of our thinking was, we can add to this process perhaps by bringing in the importance of human rights. Here's an element of this that people aren't paying attention to. If we start to think and talk about this concern in climate change, perhaps that will help to prod policy in the right direction. And as we'll see, perhaps there have been maybe some successes, but I think it's very hard for me in the time that's passed since to call this a real success. In any case, what we tried to do is to look at it from 4 different angles. So we're all aware of the climate change impacts on human rights, and we have a list of human rights that people habitually refer to: life, health, food, shelter, water, self-determination often arise, and others. But aside from the human rights effects of impacts, we also thought it's worth looking at the human rights impact of climate change policy. So we have a series of policies that are beginning to take shape around this time, to do with mitigation, to do with adaptation. We are, at this time that I'm writing, 10 years after the Kyoto Agreement, but almost 10 years before the Paris one. We suggested that we might find ourselves talking about climate change in terms of emergency, and we're lawyers, so we're working with lawyers. And of course, from a human rights perspective, the invocation of emergency is generally not a great thing. Where we find ourselves today is that, in fact, we increasingly speak about a climate change emergency, and that wasn't the case in 2007. And there, I suppose, the relevant human rights, again, David Boyd listed them, are rights to information, rights to participation, process rights when it comes to those policies, at a minimum. But there's also the impacts of policies, and I'll say maybe a bit more about that in a moment. Then our third angle was in terms of text. So you have this series of international law texts dealing with climate change on the one hand and human rights on the other. And we were wondering about the extent to which they converge or are coherent or diverge in various different ways. And here the context is an international law field, which I'm sure you're all aware is characterized by fragmentation. There's a series of bodies of law dealing with different topics that often seem to exist in isolation from one another without any clear sense as to how they're supposed to work together. And I think this is exactly what we see happening when we look to recent cases coming through the human rights courts dealing with climate change. They look to both bodies of law and see how they can fit them together. Another excellent example, perhaps, is the question of climate refugees and migrants, and the long-standing question as to whether or not they fit within the 1951 Geneva Refugee Convention. And the very significant pushback from the bodies tasked with looking after that convention, the High Commission on Refugees and the IOM, making it very clear that they're not going to accept even the term climate refugees. This is, I think, one of the quite profound problems we meet. And so that takes us into the general context. We wanted to step back a bit further again. You have this set of texts doing different kinds of work, and you have a context in which that takes place. Fragmentation is part of that context. Another part, perhaps, is the way the climate change international law apparatus itself is rooted in a particular international law moment from the 1960s, 70s, which we often call the New International Economic Order. So the UNFCCC is full of terms that think about the relation between North and South and the post-colonial context and readdressing those justice issues arising from decolonization. That's a part of the package. On the other side of the room, so to speak, you have the fact that climate law arises at the same time as contemporary trade law. So the WTO was created in 1995, just after the climate change agreements. And you find this convergence between the texts. The UNFCCC's Article 3.5 refers directly to the WTO GATT agreement. So the assumption of liberal trade, the assumption that any efforts by governments to impede trade is a form of protectionism, is clearly part of the context in which climate change runs amok in the 1990s at the same time as a legal framework in principle comes into place. Okay. Ayosha, you're going to have to tell me if I'm going over here, but I'll keep going until you tell me to stop. Our next element to this puzzle at the time was to try and identify human rights within a broader context of what we started calling and came to be called by other people at the same time, climate justice. And that can mean many different things. So one way of trying to break it down into meaningful bits is to think about it in terms of 4 different or 5 different sorts of justice claims that are made in the climate context. And when we do this, and you'll see as I do this, what we were really focused on at this time, and to me it still seems to be the main focus relevant to human rights that is often neglected when we then turn to human rights instruments, is the fact that northern countries, wealthier countries, former colonial powers are historically responsible for the climate problem. They've contributed most to it. The wealthier a country is, the larger its carbon footprint is. So to this day, prosperity aligns with responsibility for causing it, if you like. While at the same time, and almost by coincidence, the countries that are most deeply and profoundly affected by climate change are mainly in the global south, are mainly relatively poorer, and are mainly former colonies. So you have a set of historical justice issues that are sort of mapped onto a set of contemporary justice issues, that responsibility among the North and the vulnerability in the South. So the first justice claim is one about climate impacts. It affects countries' behavior, predominantly in wealthy countries, increasingly, of course, at this point in China and India are major contributors as well, affecting people in other parts of the world. And that gives rise to a disbalance, an extraterritorial problem, a problem of harm, a problem of making amends, a problem of compensation. The second major justice claim had to do with the removal of fossil fuels in the future as a motor of growth. So if poorer countries were to contribute to addressing the climate problem, they would effectively find themselves unable to address their own developmental problems. And this was, of course, the point of view of the Global South right from the beginning of climate negotiations, and is why it's positioned within the new international economic order. This is, of course, a set of human rights concerns, because the way in which we address the rights to food, health, shelter, and water, and so on, are through development. We haven't really found other ways of doing that. So if we're going to ask for countries to stop using fossil fuels, we create this problem of a potential development freeze or of locked inequality. The third problem is a procedural justice problem, which is, well, who gets to decide how we sort these things out? And the problem there tends to be one of there being no forum within which a global public, so to speak, can come to agreement as to how best to do these things. And then the fourth justice claim, which I think is often in the background but quite important, is a question of ownership rights. And that is the fact that those countries and companies that have been using the global carbon dump, that have been emitting carbon over the decades and centuries, have, you might say, acquired a right to usage, and they don't want to give it up. And of course, that plays a very big role in the background of all of our discussions about climate change. The fact that we're asking people who are using something to stop using it, and they don't want to stop. And they have law on their side in the main. So a problem of acquired rights. And to this, you might add a fifth concern that you would characterize as a justice concern, and that is a criminal law concern. Why is it that the amount of harm caused by climate change doesn't fall into our international criminal framework? Once again, we see that there are moves to try and make that happen, but it's very slow progress, and it's, in my view, quite unlikely that we'll see much progress in that area anytime soon. Now, curiously, for those various, the four that exist, justice claims I just outlined here, we find them addressed to some extent within the climate regime. So the problem of making amends is addressed by a global mitigation policy. Emitters must stop, cease and desist from emitting. And to some extent, a global adaptation policy, which expects at some level transfers from the high emitting countries to the low emitting countries to make up for or compensate for the loss that they are experiencing and the harms that they've experienced due to climate change. Now, it's never called compensation, but that's the sort of frame in which it takes place. To the second problem, developmental freeze problem, the UNFCCC treats it with what's called technology transfer. The idea we would make technologies available to address the developmental drawbacks and thereby promote, in principle, the capacity for progress in typical areas of human rights. For procedural justice, of course, we have the UNFCCC process itself, the caravan that appears every year of 10 or 13,000 people. And for the formal justice problem, the problem of entitlements or ownership or acquired rights, we have the recognition through the various, in particular, market schemes, the flexible mechanisms of Kyoto and Article 6 of Paris, perhaps, which puts in place the notion that those who have been using this stuff to date have a certain right to it, maybe reducing or capped over time, but in principle, we start from that premise, a recognition of that existing rights. And over time, I think what we've seen is that these various different elements of the climate regime have expanded or contracted at different rates. Technology transfer is almost invisible today, whereas the ETS, various ETS regimes are quite prominent, at least in the way we think and talk about climate policy. Okay, what I was going to do, I may be as well to stop there, was quickly go through a set of recommendations we made at the time to assess the degree to which these now seem to have been met or not in the intervening decade and a half. Will I say something quickly about that, or should I?
Yes, you're well within your time, so you have actually 10 more minutes if you wish.
Okay. Oh, good. Okay. Good. Okay. So we outlined at the end of this report here, which you can find in SSRN because the actual organization is no longer with us, has an appendix, a couple of appendixes, one of which picks out from the IPCC reports and various other sources where we locate human rights concerns arising in climate change scenarios and predictions, and a second of which outlines areas for future human rights engagement. And at the time, there was almost nothing going on. So among them, they're under four headers here: advocacy, mitigation, adaptation, and litigation. When it came to advocacy, we were suggesting, we weren't alone in this. There were various, SEAL in particular, the Centre for International Environmental Law, was incredibly active and remains incredibly active in this area, doing a lot of this kind of work too. We met with them at the time. First was to insert human rights sensitivity into a post-Kyoto regime. So we were negotiating Paris. We were actually negotiating Copenhagen at the time, 2008, 2009. Copenhagen came to nothing, so it becomes Paris. And the move was to bring human rights directly into the climate change regime. What we were essentially doing here was dealing with two silos, two different epistemic communities, right, who didn't really speak each other's language, and trying to get them to converse and dialogue. And there was a big push to refer to human rights in the Paris Agreement, which is undertaken at the highest level. I was working at this time with Mary Robinson. She was involved with the International Council on Human Rights Policy. She was very well placed to bring these things into these international negotiations. There were concrete proposals to have human rights wording in the Paris Agreement. They were rejected ultimately, and what we get, as you may be aware, is a paragraph in the preamble, which is pretty vague and hard to follow, on the importance of considering human rights dimensions of climate change. So some success, maybe not as much as we might like. Certainly nothing concrete or enforceable, as we like to say. The next was this flip side of that, was bringing climate change concerns into the foreground of existing human rights advocacy. Around about 2008, 2009, I visited Human Rights Watch and their headquarters in New York, and Amnesty International in London, and various other organizations, to raise with them the idea that maybe they should be thinking about climate change. And they were all interested, but they were very, very cautious. It didn't look like a traditional human rights problem to them at the time, for the obvious reason that we didn't really have any victims, and human rights organizations need victims. We're not in the habit of forward thinking about problems that may occur in future with abstract, if you like, victims. So they were slow, and as you know, got there about 5 years later. And now, of course, it's top of the agenda for these guys. And I think that's fantastic. That's a great success. Not my success, but a general success. That said, I still often find myself wondering, well, what can they do with this problem, right? The main problem, just to reiterate, when it comes to human rights is, I think, the problem of extraterritoriality. We have victims in one part of the world and emitters in another. And there's a certain matchup, but it's not a very good matchup. So that's something I'll come back to later on. So we hope that you might then get input from human rights organizations into things like the construction of a mitigation regime. If you look to the work of a group like SEAL or even Human Rights Watch at the moment, they're very, very active in this area, actually. There's endless lobbying going on at the COPs and in Bonn and so forth to try and bring human rights concerns into REDD+ programs, into the Article 6 negotiations, for example, as they continue, with a certain amount of success. I'm not sure success is the word, but anyway, it's there and it's present and people are aware of it. Ditto when it comes to adaptation and technology transfer, and I'll say more about those maybe in a minute. And then the question of the Sustainable Development Goals, or the right to development. As I'm sure many of you are aware in this room, the right to development has a checkered history as an element of the human rights regime. It was always associated with the new international economic order and seen as a very political tool to address power differentials between North and South, if you like. And appears in the UNFCCC in this very peculiar form of states have a right to promote sustainable development. That said, with the replacement of the MDGs by the Sustainable Development Goals in 2015, we wind up having at least a language, as international lawyers will tell you, a very loose and in lots of ways unsatisfactory language and baggagey, but nevertheless a language which seems to link together a set of human rights concerns with a set of developmental concerns with a set of climate concerns, and that's all to the good. In the IPCC process, for example, the SDGs figure very strongly. I'm sure some of you are aware, there's constant reference back to the SDGs. That's kind of become mainstream, if you like, through international policymaking. And then the other area of advocacy was this idea that maybe we should be thinking about climate change as a criminal offense rather than a kind of a tort. And that takes us, I suppose, into ideas such as ecocide. Wait, what happened there? I think I just, oh yeah, sorry, yes. So a next area was litigation. And here we foresaw a number of spaces in which we might expect increasingly over time litigation to happen. Now, at that time, I think we were somewhat concerned that litigation was most likely after the fact. The problem with law is, as I say, you need concrete victims. So the timeline with climate change, as you're aware, is that we get ourselves to a situation in which we're sort of not dependent for the next 20 or 30 years. It's very difficult to look backwards and fix things that have just happened because, if you like, the gun is already loaded for the next few decades by the time something has happened. And so from that point of view, litigation is a blunt instrument here. And one would expect policy, planning to be a much more effective way of dealing with climate change. But there are, of course, all sorts of other problems too. In the case of the very obvious example of state responsibility, there was already form in the form of Tuvalu having at one point mooted the idea that it might take the United States to the International Court of Justice on the basis that Tuvalu was sinking and the US was a major emitter. And the way the story goes, getting a telephone call from the Department of State to say, if you pursue this, we'll cut funding and make sure that you're not able to get any further funding, and stepping back quickly. Now, whether things have changed or not, from that perspective, we are aware, you're aware that, of course, Vanuatu is now doing something similar to that. They're not suing, so to speak, the US, so to speak. They're seeking instead an advisory opinion. And the path of the advisory opinion has been mooted repeatedly over the last 20 years. Some of you will be aware various states have lifted it and then dropped it again. Bangladesh was interested for a long time. Pakistan was. And finally, Vanuatu are going ahead with it. I'd be very interested to hear what people think in the room. I think it's admirable in many respects, but also very dangerous, because it's very easy in this context to get a result that you're not really looking for, and quite difficult, I think, to get the result that you hope for. And if you don't get what you want, then it's a bit hard to know what to do next. But there's also, of course, as you're aware, a process before the Inter-American Court, which David referred to a moment ago, brought by Colombia and Chile, asking something similar. Extensive question, looking at the various elements of human rights and climate change law and other areas of international law that seem relevant. So that's something. Okay, worth evaluating perhaps. The next is, of course, the notion that you might want to target government regulators or public officials for harms that are actually happening or that are perhaps imminent due to their failure to address the problem. So the failure to regulate, or maybe you're looking for injunctive relief, perhaps saying, well, these particular processes should stop now because they're causing harm or will cause harm. And over the years, we've increasingly seen this particular tool being raised. The best known example, of course, in the human rights domain is probably your agenda, the Dutch case, which is seen in many respects as being groundbreaking. I tend to be a little bit of a skeptic on these things. It was good, of course, to win a case like Agenda and to set the precedent that a court can direct a government to alter its policy in climate change. The actual alteration, of course, was relatively minimal, and it was after the fact because the court process took so long that by the time we had the final Supreme Court ruling in the Netherlands, the actual deadline was a couple of days later. So the state wasn't really in a position to do anything about policy, and the court was aware of this. So the processual elements, the political elements, the legal elements tend not to match very well in this space. Also, of course, Agenda raised the problem of the rights of people outside of the Netherlands in the first instance ruling, and got nowhere with that. And I think that's a problem. Similarly, in the Neubauer case in front of the German Federal Constitutional Court, the victims from Bangladesh and Pakistan Nepal also applied in that case and were given, in principle, standing by the court. And then the claims were essentially set aside. Although, from a certain point of view, they're far more pressing in Bangladesh than they are in Germany. So again, the court was willing to step in and say the government needs to do a bit more, but it wasn't willing to step in and say Germany has obligations towards people in Pakistan and Bangladesh and Nepal. And we find exactly the same thing then happening when it comes to the European Court of Human Rights. The Duarte Agostinho case is notable for the, I think, utterly unnecessary, frankly, absolute dismissal of any acknowledgement of extraterritorial obligations in the context of climate change with regard to persons living outside the Council of Europe, drawing on previous case law, which had nothing to do with climate change in the main, which was to do with war situations, and which, of course, was very firmly rejecting the notion of extraterritorial responsibility. Now, the weird thing is, it seems to me, and maybe people have views about this in the room, that there were all sorts of opportunities before the court to find another way to think about this problem of the extraterritorial effects of greenhouse gas emissions, and the court simply refused to take it on. They did even worse, in my opinion, at least, with the Swiss case that actually went through, the Klima Senioren case, where they literally refused to find anything wrong with Swiss policy. This is despite the fact that UNEP and the IPCC have made it clear that current NDCs aren't adequate to the Paris targets. Apparently, the court didn't feel there was any way they could bring human rights to bear on the substantive elements of climate policy. They stuck entirely to the procedural elements. And in the Swiss case, those were pretty unusual elements in the first place, because the law had been rejected by referendum. So maybe other people have other views. It's been generally hailed as a good thing. I'm very uncertain. I think if a court can't even say to the Swiss government, this is an inadequate policy, then we're not going to find human rights courts helping here. Other people might think differently. Next was, of course, private actors, and corporate actors are responsible in all sorts of ways for climate change. You might make them the principal protagonist. And again, we have the extraterritorial issue that carbon emissions produced in territory X have impacts in territory Y, and that problem has been made most explicit in the case that's been in front of the German courts for a very long time now, involving the utility company RWE and a Peruvian farmer by the name of Luya. I'm not quite sure what's happened with that case. Maybe somebody knows more than I do. It's been waiting for quite a while now, and I understand they want to take account of the various other kinds of litigation happening in the world. Duarte Agostinho will not be encouraging from this point of view, but it's a civil claim in principle. And were anything to happen, of course, it would be seismic. But that's also anyway. So other reasons one might want to target private or corporate actors is for direct human rights harms. So the Philippines case, the Human Rights Commission in the Philippines brought a case quite like Luya, but the other way around, where they were trying to charge carbon majors, or seeking a way to find responsibility amongst the carbon majors, 90 different companies around the world in fossil fuels and cement, for the typhoon that hit Philippines in 2011. And it was a wonderful process with which I had a slight bit of involvement in the LSE. Not though leading to anything, enforceable in the international domain.
Sorry, Professor, if you could please conclude in a minute.
I got there. I got through my
Okay.
Okay, good.
Thank you.
I can. You can see the rest of these examples haven't really haven't got very far. Some investment activity when it comes to companies, and investor activism, you might say, and with the question of trade sanctions. What we find instead is a move towards the CBAM in the EU context to address emissions abroad. Okay, I won't go through these two, just to point out that there were also questions about adaptation policy and mitigation policy. In none of which I think have we made great progress when it comes to bringing human rights to bear on these situations. The adaptation is very far behind. Technology transfer hasn't happened at all. And the last thing, simply to say that we didn't, in that report, talk about the right to a clean and healthy environment, which I think maybe we want to talk about in the room. It may add something. The question of future generations was left out deliberately, and I'm now on record as standing against future generations as a useful or viable way into the climate problem. And again, I'm happy to talk more about that. And the question of loss and damage wasn't on the agenda. It was just coming up, actually, around about that time, 2009, which, of course, is worrying that we're now at a point where what we're concerned about is irreversible harms instead of harms that we should have and could have obviated before they took place. So I'll stop there. Thank you, Arisha.